Good morning. Can everyone hear me?
Yes, Nick.
Okay, great. Thank you. So good morning. My name is Nick Reuter. I'm a member of Morris Manning's Corporate and Mergers and Acquisitions Group. Today, though, I'm going to be talking about what is probably, at least one of the hottest topics around in the business community, and that is the stimulus loan programs that have recently been passed by the federal government. I'm going to start with a quick overview of the available financing options, and then we'll delve more deeply into some of the specifics. The first is, of course, the Paycheck Protection Program. This is the one that you have probably been hearing a lot about over the last few weeks. These are nominal interest forgivable loans for businesses with under 500 employees. The second is the Economic Injury Disaster Loan Program. This is a program that has actually been in effect for some time prior to the COVID crisis. Unlike the PPP, these are real collateralized loans. Eligibility generally matches that of the PPP, but again, we'll get into a little bit more detail on these. The third is the Mid-Sized Business Assistance Program, which has recently been renamed the Main Street Lending Facilities Program. That is really applies to mid-sized businesses, although as we'll discuss, based on recent guidance, that program may also be available to smaller companies as well. And then the last, which I won't get into too much detail on, but just mention that if you do have an existing Section 7A loan from the SBA, then those loans are now eligible for forgiveness for 6 months. Go on to the next slide. All right, so the PPP loan, Paycheck Protection Program. We'll start with just a quick overview of the terms. They have 2-year term loans. There's no prepayment penalty. They accrue interest at a 1% fixed rate, and interest payments are deferred for the first 6 months. Interest will accrue during that time, but it is not payable. These loans are non-recourse. There's no collateral. There's no personal guarantee, which differs from most other SBA programs in really any loan. Use of proceeds, that is limited. It's limited to payroll costs, mortgage interest. I should note that there's some unclarity about whether it can also be used to pay interest on other debts, rent, and utilities. Go to the next slide, please. All right, eligibility. Generally speaking, all for-profit, certain nonprofit, independent contractors, and sole proprietor businesses are eligible. There are some limitations, which we'll get to momentarily. Size standards are, the SBA has always employed size standards to determine whether a business is eligible for their programs. Here, those standards have been loosened a little bit because they have removed the requirement that business be under certain revenue thresholds. Instead, they're really just requiring that you have 500 or fewer U.S. employees. Now you'll see here on the slide it says, or you are a small business concern. What that effectively means is if you would have been eligible for an SBA loan prior to the CARES Act, you are eligible for the PPP program. In addition, eligibility has been expanded to all businesses that have 500 or fewer U.S. employees. Now, there are certain exceptions to these size standards. The most notable exception is for what the SBA, what the CARES Act refers to as accommodations and food services businesses. These are businesses that have an NAICS code of 72, beginning with 72, and it's effectively restaurants, hotels, some dormitories, some businesses that service the food sector. For those businesses, the 500 or fewer limit does not apply. Well, it does apply, but it applies on a per physical location rather than for the company as a whole. So if you were, for example, a hotel chain, you would, the 500 limit, as long as no single hotel had over 500 employees, you would be eligible. I should then move on to the affiliation rules, and these are important for all businesses, but particularly those that are backed by private equity or venture capital. So affiliation rules have been in existence for a long time, and the SBA has a long list of regulations and administrative case law that dictate how those affiliation rules apply. And basically what they are is they're trying to make sure that a business doesn't qualify as a small business simply because it is broken up into multiple different legal entities. So the SBA will look not only to your company, but also to any of its affiliates when it determines whether you are eligible for a PPP loan. Where this comes into play most notoriously recently has been with venture capital and private equity backed companies. Because according to the affiliation rules, which look for control over those companies, private equity firms and venture capital firms, along with all of their other portfolio companies, would all be grouped together and treated as affiliates for purposes of determining whether they have 500 or fewer U.S. employees. And of course, most venture capital and private equity portfolios consist of a number of companies that are ultimately going to have more than 500 employees. There are some exceptions to the affiliation rules. Again, accommodations and food services businesses are exempt from the affiliation test. Also, if your business has received financial assistance already from an SBIC, then it would be, that's a small business investment company, then it would also be exempted from the affiliation rules. And finally, if you are a franchise, you're exempted from the affiliation rules. The last point on eligibility is that you do need to demonstrate a need. Now, this need demonstration, the bar is rather low. You simply have to make a certification to the lender that the economic uncertainty created by the COVID crisis makes these proceeds necessary to continue your ongoing operations. We don't really know exactly what that certification means, and so we advise businesses to carefully document why they need these funds, and that documentation should be kept internally in case anyone ever challenges whether you really at the time believed that they were needed. We go on to the next slide. Loan amount. So to calculate your loan amount, you are going to take the borrower's average monthly payroll cost for either the calendar year 2019 or the trailing 12 months from the date of your application, whichever you prefer. And you are then going to multiply that by 2.5 times. There is a $10 million cap, which most borrowers are not hitting, but some might. Payroll cost is a defined term, and it includes, of course, as you would expect, salary, wage, commissions, and similar compensation. It also, for relevant businesses, would include payments of cash tips. It would include payments for vacation, parental, family, medical, or sick leave. It includes any allowances for severance pay. It would include payments for group health care and retirement benefits, and also payment of state or local tax assessed on the compensation of your employees. Notably, that does not include federal tax. There are some alternative calculations applicable for seasonal and new businesses. I won't get into the details there, but if your business was not in operation in 2019, there are there's an alternative calculation that you can use. And if your business is seasonal, there's also an alternative calculation. move on. All right, this is the most important aspect of the program for most borrowers, and this is the principal forgiveness. Again, this is a loan. It does have to be repaid back, but up to 100% of it can be forgiven depending on how you spend those proceeds in the first 8 weeks from the loan date. Now, there are some limitations. Again, the loan proceeds may only be used for eligible purposes. And for principal forgiveness, there's a 25% limitation on the use outside of payroll cost. They really want you to use these funds largely to retain employees. There's a forgiveness reduction now. So after you have spent these proceeds in the first 8 weeks, again, all of that principal will be forgiven. However, to the extent you have had a reduction in the number of employees or a reduction in the salary of your employees compared to a period in 2019, and that period is February 15th through June 30th, 2019, the amount that is forgiven will be reduced. And there's some calculations that they have set forth for borrowers to calculate what that reduction would be. For the salary reduction, it's a reduction of more than 25%, and it only applies to employees making less than $100,000. You do also have the ability to restore jobs. So if you did have any reductions between February 15th and April 26th of this year, and you restore those jobs, then that reduction will not be made out of the principal forgiveness. Okay, the next slide, please. Okay, the economic injury disaster loans. These are, we're going to spend a little less time on the other loan programs since they tend to be less relevant for most borrowers, but these are real loans, up to $2 million working capital loans. Again, this program has been in existence for some time. Anything above $200,000 will require personal guarantees, and collateral is also required under these loans. So they're not quite as attractive as the PPP program. Eligibility it generally matches the eligibility that I discussed for the PPP program. The most interesting part of this loan program is the emergency grant. Upon application, a borrower or an applicant at that point can receive a $10,000 emergency grant. That $10,000 will be provided within 3 days of application. There's no obligation to repay the grant, and if you are not approved for your loan, or if you are approved and do not accept the loan, you do not have to pay this grant back. The only time you would have to pay it back is actually if you do accept the loan. It will be reduced or subtracted from the amount. Move on to the next slide. All right, the Main Street Loan Facilities. This is a very new program. We only just got guidance about this program late last week. Businesses with up to 10,000 employees or up to $2.5 billion in 2019 annual revenues are eligible under this program. Now, originally, the CARES Act contemplated that an eligible business would have to have more than 500 employees and less than 10,000. However, the newest guidance suggests that the requirement to have greater than 500 employees may not actually be in place anymore. We suspect that this limitation was lifted in light of the recognized limits of the PPP program, such as those I mentioned about venture capital-backed companies. The program contemplates both new loans and the upsizing of existing credit facilities. So if you have a credit facility with an eligible lender, which is essentially any insured U.S. bank, then you can increase the amount of that credit facility under this program. Borrowers must be organized in the U.S. They must have a majority of their employees and operations located in the U.S. And they must have had positive EBITDA for calendar year 2019. The loans are made through eligible lenders and backed 95% by the Federal Reserve. The way that works is that the Federal Reserve and the Treasury Department are forming a special purpose vehicle that will then purchase a participation interest in these loans, thus reducing a lender's risk to approximately 5%. The loan terms are fairly attractive. They'll have 4-year maturities. The amortization of principal and interest is deferred for 1 year. They bear interest at an adjustable rate. That's the equivalent of the federal overnight rate, which is currently 0.1%, plus 250 to 400 basis points. The minimum loan amount is $1 million, and the maximum is effectively $25 million, or an amount that, when added to the borrower's existing outstanding and committed but undrawn debt, does not exceed 4 times the borrower's 2019 EBITDA. So effectively, it's an EBITDA coverage ratio. There's no prepayment penalty, and again, no collateral, except for on upsized loans. To the extent a loan was already collateralized, that collateral would continue to apply. Now, the interesting thing about this program, the borrower is required to make some attestations, including with regard to needs, similar to the PPP program. The use of proceeds may not be used to refinance existing debt, but proceeds do appear to be eligible for all other working capital purposes. There are some post-closing restrictions that the borrower needs to comply with, and these include limitations on stock buybacks, increases to executive compensation for those making greater than $425,000 a year, and the payment of dividends on common stock. The Fed intends to issue more guidance in the coming days. There's still a lot we don't know about this program, but it is very interesting. And again, it appears that it may be applicable both to small and mid-sized businesses. That's it. We can move on to the next slide. And I'm going to hand this over to Eleanor Stone.
Great, thanks, Nick and Juanita and Corpay, and good morning to everyone in attendance. My name is Eleanor Stone, and I'm a partner in MMM's Employment Group. For this portion of the webinar, I'd like to discuss some of the considerations to think about when implementing certain workforce restructurings. Now, workforce restructurings are an unfortunate reality of today's time, so we wanted to devote some of our time to this important topic. First, though, we're going to talk about the FFCRA as a kind of refresher for those of you who know about it already. There have been some changes in the past couple of weeks, and then as something new for those of you who are unfamiliar with it. The FFCRA is the Families First Coronavirus Response Act, and it has added new requirements for paid sick and family leave. It applies to employers with fewer than 500 employees. For the sick leave component, this is 2 weeks. It's up to 80 hours at employees' regular rate, up to $511 per day. And the paid family leave component effectively provides up to 12 weeks for employees to care for a child whose school or place of care has closed. And this is at 2/3 of the employee's regular rate, up to $200 per day. I say effectively because an employee can't use 14 weeks. The employee can't use 2 weeks of the sick leave and 12 weeks of the paid family leave. Also, if an employee is eligible for FMLA under your FMLA program, the paid family leave runs concurrently with that. So if your employee has already exhausted unpaid FMLA, the employee does not then get an additional 12 weeks of paid family leave. So that's something to keep in mind. Refundable tax credits are available, and they're applied against all tax liability. Employers don't need to wait until next quarter to take tax credits. Forms are now available from the IRS to report. Employee notices are required. There's a DOL poster on the DOL website that's required to have been sent by email to and also posted in a prominent place in the workplace for when they come back by April 1st. Can we go to the next slide, please? Now, in terms of eligibility versus usability, there's an important distinction. If an employee is completely laid off, not performing any work, you have no obligation to provide paid leave under the FFCRA. The employee has no eligibility. And this is true regardless of whether the layoff is due to a federal, state, or local directive related to COVID-19. So if the employee is under a shelter-in-place order, doesn't matter what it is, if they're not working for you, no sick leave. Now, if the employee is working on a reduced schedule, you may have to provide paid leave under the FFCRA, but importantly, the employee is only potentially eligible for that sick leave when the employee is scheduled to work for you. So a lot of employers right now are doing, maybe 2 weeks on, 2 weeks off to reduce payroll costs. The employee can never get paid sick leave from you during the 2 weeks off, only during the 2 weeks on. So if an employee thinks, hey, I've got COVID-like symptoms, I want to go get it checked out, that employee cannot get paid sick leave from you during the times that you're not scheduling that employee to work for you. Also, if you have an employee whose hours have been reduced, do note that that employee, you look at that employee is entitled to sick leave based on the hours the employee worked for you before you reduce the hours. So as I mentioned on the last slide, employees can get up to 80 hours of paid sick leave. That's based on before the COVID-19 crisis. And FFCRA leave may be taken intermittently, but only if you guys come to an agreement about it. The DOL cautions that we want to stop the spread of COVID-19, so it may be best not to have an employee take leave intermittently if there's a risk that that employee could spread the virus to other people. Can we go to the next slide, please? Thank you. Now with workforce restructuring, first one to talk about is layoffs. So layoffs with both, there are two types, temporary layoffs, and those are less than 6 months, and permanent layoffs, and those are greater than 6 months or indefinite. Both are a termination of the employment relationship, and that's going to include possible final pay obligations like PTO if required by state law, or if required by your company's prior practices or policies, and possibly severance if required by your company, or as a best practice to offer severance in exchange for a release of claims against your company. And then note that layoffs could trigger WARN Act issues under federal and or state mini WARN laws. Now, temporary layoffs less than 6 months are not considered to be employment losses under federal WARN, and the same is true under many, but not all, state mini WARNs. That's if you can make a good faith showing that you intended to bring the employees back within 6 months. Otherwise, you're gonna trip up. That it's going to be counted for purposes of federal WARN. Under California, though, they don't care about temporary layoffs. They're going to count that for purposes of WARN. Now, permanent layoffs, those are subject to federal WARN notice requirements, which is 60 days in advance. So if you know today that you're going to be doing a mass layoff 60 days from now, that's when you would give a notice. And then under state mini WARN requirements, it's 60 to 90 days, depending on the jurisdiction. As far as what triggers WARN, under federal WARN, it's not triggered unless at a minimum you have 100 employees at least, and there are 50 employment losses, and you have, that's at least 1/3 of your workforce at a single site of employment in a 90-day period. If you look at the statute, it says 30 days, but they really look at a 90-day window, so you can't game the system and terminate people on day 31. Now, there could be applicable exceptions to the advance notice requirements. Interestingly, lately, the governor of California came out and said, okay, well, COVID-19 is an unforeseen business circumstance exception to the federal WARN Act, because how could we have known, right? And that's very good for employers. And he also said, but you still need to give notice. So if an employer found out on March 13th that we're going to have to shut down operations because of COVID-19, that means that based on what he said, you may not need you may not have needed to have given 60 days notice, but you will need to have given notice at the moment that you knew. But note that we're starting to see our first round of litigation where employees are arguing that employers are using COVID-19 as a false reason for a mass termination in order to give no notice under warrant or less notice when they really had another business reason anyway, before COVID-19 even began. So that's something to keep in mind. I expect we'll continue to see some interesting developments here. And then with respect to unemployment, a terminated employee, of course, is going to be eligible for unemployment benefits. There are some state-specific quirks. In Ohio, for example, there's a COVID-19 specific notice. I'm sure many other states are doing the same thing. In Georgia, very oddly, employers are required to file partial claims and total claims on behalf of their employees in any week in which an employee, full-time or part-time, works less than his or her regular full-time or part-time schedule. And if they don't, they will be liable to the Georgia DOL for the full amount of benefits paid to the employee. And of course, that would apply to anyone who is laid off temporarily or permanently, but also to anyone who's furloughed or has hours reduced. And we'll get to that in a minute. The idea is to make the employee whole. The most important takeaway about unemployment is threefold. First, to know the obligations in your state as an employer, and if you don't know, to seek assistance from counsel. Second, any layoff or slowdown of work, and again, we'll get to that in a minute, will allow your employees to file for unemployment or require you to file on their behalf. Third, your employees may not ultimately be eligible for benefits because they may be earning more than the max weekly benefit. And the max weekly benefit is an amount set by each state and is equal to what the employee is making plus $50. But you still should file on their behalf each week if you're in a state like Georgia where you must do so, and let the state DOL sort it out. And you should still timely respond to any inquiries from the state DOL, whether you're in Georgia or elsewhere. Otherwise, you could be penalized if it turns out the employee was eligible for benefits. Next slide, please. Oh, I'm sorry. Actually, can you go back to the previous slide? Furloughs may offer flexible arrangements in this complex employment time. So, for example, you may be able to find a creative way to retain all of your employees on a reduced schedule for a temporary period until we get over the hardest part of this crisis and cash flow gets better. They're not a perfect solution, though. They can raise wage and hour issues for exempt and non-exempt employees, and it's important to be vigilant about that and consult with counsel as necessary. For example, do keep in mind that when employees are on furlough, there shouldn't be any working. So if, for example, they are not working Monday, Wednesday, Friday, managers should be instructed that Monday, Wednesday, Friday, those days are off limits. Reminders to employees and managers of timekeeping policies and potentially implementation of new policies for remote working and timekeeping are all great ideas. And how furloughs are different from temporary and permanent layoffs, they are a bit different because there's not a termination of the employment relationship except for very rare circumstances, like you live in California, and so everything in California is different. And if your furlough lasts longer than 30 days, then it's going to be a termination. WARN is also generally not a problem unless the furlough goes longer than 6 months. And as for unemployment eligibility, as we discussed a little bit ago when we were talking broadly about unemployment, it's usually going to be triggered by a furlough, because whether or not the employment relationship is deemed terminated, you may have an employee whose furlough arrangement is 1 week on, 1 week off, or reduced hours. So again, the whole idea of unemployment benefits is to help make the employee whole. So again, for any period of time in which the employee is out of work or earning less, the employee can seek unemployment benefits. But again, note that employees who are furloughed by having some hours reduced may not ultimately be entitled to benefits because they're making too much money, so they can still file. Or if you're in a place like Georgia, you should file on their behalf for each week of the furlough. Next slide, please. Thank you. Now, in addition to layoffs and furloughs, many employers are reducing hours or compensation. There are many similarities between reduction of hours reduction of compensation. So here's a chart that shows just at a high level some of the similarities and differences between these two workforce restructurings. So neither is an employment termination, of course. As both, it's critical to ensure, just before you're even considering it, whether it's permissible under any collective bargaining agreements, any employment agreements, offer letters. You also may need consent from your board of directors for a compensation reduction. There may be, with benefits, it may be impacted if you reduce hours. Your carrier will be able to help you there. As for FLSA issues, with an hours reduction, note that exempt employees will still be entitled to their full compensation for any work week in which they work any hours. With a compensation reduction, ensure that your non-exempt employees who are still working the same hours are still getting minimum wage at least. And ensure that your exempt employees are not now kicked out of their overtime exemption or exemption. So is there still a basis for their ineligibility for overtime? As for WARN Act issues, this comes up with an hours reduction, and an employee counts towards the WARN threshold if his or her hours go below 50% in each month of a 6-month period. And finally, as for whether unemployment obligations are triggered, they are triggered with an hours reduction, even if, as we previously discussed, the employee is not ultimately eligible for benefits because he or she earns too much. But as we said, go ahead and file. If you're the employer, you have to file that you don't get penalized if it turns out the employee ends up being eligible. And that is all from an employment perspective that I have.
Thank you, Eleanor. Nick, would you like to talk about the MMM resources?
Sure. So our firm has put together a task force dealing with these issues that we discussed today, as well as a number of other issues that come up relating to COVID-19. We are going to make sure that these slides are sent out to everybody that attended this webinar afterward. And so you'll have access to all of these materials that are on this slide and more. We are updating materials daily. Our FAQ on the Paycheck Protection Program is updated almost daily, or at least as frequently as further guidance is released. And of course, if you have any questions about specific issues, I know we're going to do a little FAQ here. But if you have any other specific questions, please feel free to reach out to either Eleanor or me.
Thank you so much, Nick. And that brings us to Everett.
Thank you, Nick. Thanks, Juanita. If you can go to the report page. I know we're limited for time, so I will just highlight a couple of things from corporate payroll services side. Eleanor mentioned the refundable tax credits through the CARES Act or also the FFCRA. I just wanted to let you know those refundable tax credits that you would pay out on wages through payroll, if you have enough 941 taxes available on that particular payroll, you are able to get a credit immediately versus waiting for the quarterly return to be filed. There's also a new form 7200 that the IRS has released, which we will be able to handle that on your behalf. So any additional credit that's owed outside of payroll will be submitted to the IRS on form 7200. And that again will be filed each pay period as it's needed. Regarding the loan calculation report that you have available on your screen, Nick mentioned payroll costs and what calculates what types of payments or benefits can be factored as the payroll cost. So we do have a report available online. If you're not an online user, just feel free to call the office. You'll be able to enter in your period dates that your loan officer would request, cost. Typically, the 12-month look-back period will default, or you could also change that to January 1st, 2019 through December 2019. When you'll have to select the pay types for calculating the earnings. We do exclude payments made to 1099s, independent contractors, and also any expense reimbursement payments that are paid during that time period are excluded. You'll just have to also exclude any additional pay type specific that you might have that should not be factored into the eligibility as payroll cost. The state unemployment insurance that's paid will be automatically factored on the report for you. Juanita, if you can go to the next slide. This is a sample report. Again, it's available online. The only thing that you'll have to enter is any additional health insurance benefits from your group health plan paid by the employer, or also retirement benefits employer contributions that are paid on your, to individual plans, to your individual employees. Those would have to be entered, and it can be reflected on the report for you. If you have a retirement plan through corporate payroll, that we will provide that information on the report. All right, thank you.
Thank you, Everett, Eleanor, and Nick. And now I'm going to read some of the questions that we have. But we have a good amount of questions, so I will get through them. I'll leave the contact information on the screen for those of you who need to get that. But again, we will be providing a copy of the recorded presentation along with the slides to all attendees. So the first question I have is, can the employee retention credit be used along with the deferment of Social Security tax? Who would like to take that question?
I can answer, but Eleanor, if do correct me if I'm wrong. We did not read any guidance from the IRS regarding that, so our understanding is yes, you can use both for the 2020 tax year.
You may be muted, Eleanor.
Yeah, I agree with that.
Okay, thank you. And our next question is, we've applied for the EIDL money for both our franchise locations, for both of our franchise locations via SBA.gov. I have both of the 10-digit application numbers, but have not heard anything. Is there a way to get updates, or does anyone know what the timing of that is?
Yeah, I'll address that one. I have heard the same thing from many clients, and also just anecdotally online. Unfortunately, as attractive as the program sounds, it does not appear to be working that well. And currently, my understanding is that very few businesses, if any, have actually received their advance yet. So the 3-day from application requirement has seemed to just been thrown out the window. My best advice would be to just reach out through whatever contact information is available on the portal that you applied for, but know that you're in good company. It's not just you.
Well, apparently today because of the
She been taking this,
potassium.
yeah, she couldn't take the potassium, so she's still taking them.
Okay.
That's okay.
Yeah.
The next question we have is as far as the utilities
So long you take
and
this
things
one.
like phone, mobile phone,
Yeah.
internet, power and gas be included?
Yeah, so that's a common question because neither the Act nor the rules actually define utilities. Most practitioners are interpreting those costs to include the things that would normally be prorated in a real estate transaction. It certainly would include electricity, gas, water, telephone, perhaps even internet access. I don't think it would include things like Amazon Web Services or things that would not necessarily sort of run with the land.
Okay, thank you for that. Next question is, do payroll costs include 401k and retirement savings plan deposits?
My understanding is that they do. Yes.
Okay, I think that's our understanding as well. What is the best loan for rental property? This customer owns a rental property and is afraid that the tenants will not be able to pay their rent, but the owner obviously still needs to pay the mortgage on the building.
That's a tough one, and this program, you know, it does not help every business, and rental properties are tough because the eligible uses for the loan are limited. You could certainly, if you had employees and your rental properties were owned through some sort of through a company and that had employees, you could obviously use the proceeds to cover your payroll costs and offset that against the lack of rent. However, in your situation, I would think that the EIDL program would be the most applicable.
Okay. Next question is, a client of mine with 4 employees applied for a PPP loan. The bank checked the credit score and rating of the CEO. Is that a requirement for eligibility?
No, that is not a requirement for eligibility. In fact, it somewhat surprises me. There really are no financial requirements for eligibility under the program. So that bank, I can't speculate why they were doing that, but it is not a requirement.
Okay. If you have newly hired employees in January that were on a 90-day contract hire basis, now do they become employees in this situation?
Independent contractors are not included in the calculation of payroll costs. So in that situation, if they do become employees during the 8-week forgiveness period, they would count. You could pay them out of these proceeds, but they would not have been counted when you're comparing to this time last year and the potential reduction in the forgiveness amount. But they would need to convert to employees if you wanted to use these proceeds to pay them.
Okay. If the FTE decreases since 12/31/19 calculation, how is the penalty calculated against the forgiveness? Is it based on the number of FTEs or gross salary of FTEs?
It's based on the number of FTEs.
Okay. If a company has paid 50% of its employees' health insurance in the past, but chooses to pay 100% during the 8 weeks for forgiveness fund, is this change permitted for those 8 weeks?
I have no indication that would not be permitted. There's no guidance on that specific issue of increasing pay. Of course, whether that's a good idea or a bad idea is up to you. And I do think there are some other potentially regulatory implications. In fact, Eleanor may be able to opine on that better than I can with changing benefits for certain employees.
Yeah, I think that's a good question for the carrier to check with the carrier and see how the impact, whether it's allowed and the impact it'll have on the employees.
Okay, thank you guys. The next question is, the EIDL rules changed from 10,000 grant to 1,000 per employee. This person owns a real estate company and is not getting paid from the tenant. And I guess wants to know, I think the question has it changed?
Yeah, yes, that's so the grant amount is still 10,000, but they have imposed a rule that if you have less than 10 employees, the grant amount would be reduced by $1,000 for each employee less. So if you only had 3 employees, the grant amount would only be $3,000. all of these programs are really philosophically focused on making jobs. And so unfortunately, again, where you have situations where you're a landlord and you don't have employees and you're not getting paid rent, but you still have mortgage obligations, these programs are not likely to solve that problem. The best way to handle that scenario is to work with your lender and also work with your tenant on a payment plan.
Okay. The next couple of questions I have are regarding restoring employee count. How does the restoration work in conjunction with hiring people back? What if you can't get employees to come back until week 6? How would that work with the forgiveness?
Yeah, so the way that works is the loan forgiveness, again, is reduced by to the extent that you have less employees now than you did at this time last year, generally speaking. If you bring back those employees at any time between now and June 30th, then any reduction that would have been attributable to that job loss is eliminated. Now, of course, you don't get the advantage of paying that employee for this time, and so your payroll costs would be lower if that employee doesn't come back right away. And then therefore your forgiveness amount presumably smaller, but you won't suffer the reduction.
Okay. Is there a way to be exempted from the FCRA if it impacts a person's business too severely?
From the FFCRA?
Yes, ma'am.
Yes. You have to be under 50 employees, and you have to make a claim. You don't have to make the claim to anybody. You just need to keep documentation that it is too onerous. So we recommend that an authorized officer basically make a record of his or her conclusion that it's going to cause too much of a burden. And that there are 3 things. You have to say that providing leave would result in expenses and financial obligations that exceed available business revenues and would cause your business to cease operating at minimal capacity. And the absence, and the second one is the absence of employees requesting leave would entail a substantial risk to the financial health of the business because of their skills, knowledge of the business or responsibilities, or there are not sufficient workers who are willing, able, and qualified to perform the services, and that you need their labor or services so that you can operate in a minimal capacity. And then there are a couple of exemptions for healthcare providers, emergency responders, but in terms of need-based for small businesses, that's the one.
Okay. Do you include business owner's income when calculating the requested amount for the PPP loan? Like if the business is an LLC and the owner is taxed as a sole proprietor, not on payroll?
That's an interesting question, and I say it's interesting because we just received updated guidance on this yesterday. Originally, the thought was no, because that owner was not an employee. Now, as of yesterday, guidance has come out that partners and members of an LLC that receive K-1 may include themselves in the calculation of payroll services up to $100,000 of compensation.
Okay. My next question is, do you need to file the Form 7200 if you choose to wait to file the quarterly 941 form?
No, 7200 is only submitted for advance request payment. So if they want to wait, then it would go on the 941 return.
Okay. For employees who are out at their own request, has anyone heard of them being approved for unemployment benefits? We have work they can do, we have work they can do, so they are not furloughed, but they are just choosing to stay out. Normally, they would not qualify for benefits.
No, they should not be eligible for benefits. Because they are choosing to stay out. There's work available to them.
Okay. And I think the last one you guys answered, can you please address the question of when employees have to be restored in order to get the PPP funds forgiven? I think that's a very popular question.
Yes, the deadline is June 30th.
Okay. And how is an FTE defined?
Eleanor, do you want to take that? How is an FTE defined?
Oh, FTE, I'm sorry. Okay. Full-time equivalent employee is going to be defined as, well, you have a full-time employee, let's say 40 hours, but then if you have part-time employees, you add up all the hours that they're working. So you may have and you add up all the hours that they're working in whatever period you're measuring the period in a week. If you're measuring what full-time equivalent employee is working in a week, you take your 5 non-full-time employees and you add up what those 5 employees are working in a week, and then you divide by 40, because that's what a full-time employee would work in a week, and then whatever you get is is your full-time equivalent number. If you're measuring a month, that you add up however many people you have who are not full-time or under full-time, add up all their hours that whole month, and then divide by 40 times 4.33 for a month. Does that make sense? Tell me if it does not, and I will explain further. Essentially, you're trying to see. Sorry?
No, go ahead, Eleanor.
Essentially, you're trying to see, okay, if a full-time employee works 40 hours a week or 80 hours in 2 weeks, anyone who's below that, so part-time, anyone who's not working 40 hours a week, less than that, what are they working? What are they equivalent to as a full-time employee? They're not full-time, so I've got 5 people who are working, let's say, 25 hours each. So you would take 5 times 25. If you're looking at, let's just do a week to make it easier. They're working 125 hours that week, and then you divide by 40. And that's 3.125. So you have 3.125 full-time equivalent. That's how you figure that out. So the point is, you take all the people who were working in your measurement period. In this example, we had 5. You take all the hours they worked in that measurement period. In this example, we had 25 hours. And then you get their hours, 125, and then you divide it by 40, which is the normal full-time amount for that measurement period, and then you get 3.125.
Okay. On the PPP application, do they need to specify the number of headcounts or FTEs?
I believe they do, but Nick, I think, will know better than I do.
Yeah, the number that you would be giving them is for all employees. it's a number of employees test. The FTE component really only comes into play when you're calculating your forgiveness amount.
Okay. And let's see here. I have, please explain how the CARES Act loan report is related to the 7200 form the CPS is filing.
So the wages that would be paid out as qualified wages, qualified sick leave wages, or under the FMLA extended wages, when an eligible employee gets paid on payroll, if you have on that payroll run, if you also have enough 941 tax liabilities, which 941 taxes would consist of federal income taxes withheld from the employees, Social Security and Medicare, both employee and employer share. Those wages, the taxes that you normally would be required to deposit for that particular payroll, you can request for advance credit against those taxes. So let's say if you have a tax deposit of $500 for that payroll liability, so your 941 taxes are $500, and you're paying $1,000 in qualified wages towards the sick plan, then we would be able to apply the $500 towards your $1,000 wage credit. So technically, you will not have a debit from us or from the IRS for the $500, and you have an additional refund due to you. So the Form 7200 would take care of sending you that additional refund. That would be filed to the IRS, and then the IRS would turn around and believe it would be in a form of a check, would process that. They are trying to process the refunds within a 2-week turnaround period.
Okay, my next question is, please recap the obligation of a Georgia employer on the filing of unemployment for employees that have been reduced to 80% of their normal work hours.
Sure. So for any week in which a Georgia employee is working less than he or she was working before, a Georgia employer online each week has to file a claim for unemployment on that employee's behalf. So the employer should go to the Georgia Department of Labor website. There's a big banner on top that'll direct you to COVID-19 based claims, and the employer can file there. Other states, employees have to file. It's bizarre, but in Georgia, the employer would file each week.
Okay. That was a little jumbled on my end. Was everybody else able to hear okay? How about Nick or Everett? Were you able to hear that okay?
Yes.
Okay, it may have just been my reception. Thank you. I want to try to get 1 or 2 more questions in here. This one is about the number of employees versus the payroll forgiveness. Let's say how we have all the employees back by June 30th, but only paid out 50% of the wages within the first 8 weeks. And it's because they wanted to stay on more generous unemployment benefits than actually work. But then what would the calculation be to determine the payroll forgiveness?
I'm having a little bit of difficulty on hearing you, but I think I heard the question, and I hope that you all can hear the answer. In the situation where you have all employees back by June 30th, but only 50% of the wages were paid in the 8 weeks because people wanted to stay on unemployment, which is a very common issue that a lot of businesses are having, where employees would rather be on unemployment. In that situation, unfortunately, the only payroll cost that would be forgiven would be what was paid, but you would have no reduction to that because you did get all the employees back. And so my recommendation would be look for other eligible uses for these proceeds, such as paying mortgage interest, interest on other debt, paying for utilities, things like that.
Okay, thank you so much. That's going to conclude our webinar today. I want to thank Eleanor, Nick, and Everett for all of your time and information. I want to thank all of our customers, not only for your business, but for your attendance today. Once this webinar is up and ready on our website, you will get an email with the appropriate links. I wish all of you a great day and hope that you all stay safe and healthy. Thank you so much.
Thank you.
Thank you.
Thank you.